Right.
Hmm.
Not having heard my learned friend, my lord,
Now, Senior Counsel Manendra Singh has submitted.
yes,
He was appearing for the fourth respondent.
yes,
He said something left which are in Kannada,
quite right.
you are going to submit.
Not only in Kannada, my lord, there are a few more points.
Other languages ಇದೆಯಾ?
ಇಲ್ಲ ಇದು ಎರಡೇ ಲ್ಯಾಂಗ್ವೇಜ್, ಕನ್ನಡ ಅಂಡ್ ಇಂಗ್ಲಿಷ್.
Only Kannada.
ಇಲ್ಲ ಇನ್ಯಾವ ಲ್ಯಾಂಗ್ವೇಜ್ ನನಗೂ ಆಗ್ತಾ ಇರ್ಲಿಲ್ಲ.
ನಾಟ್ ಓನ್ಲಿ ಇನ್ ಕನ್ನಡ, ಬೇರೆ ಯಾವ್ದ್ರಲ್ಲ ಇದೆಯಾ?
ಇಲ್ಲ ಇಂಗ್ಲಿಷ್ ಅಷ್ಟೇ,
ಆಯ್ತು
ಕನ್ನಡ ಅಂಡ್ ಇಂಗ್ಲಿಷ್.
ಆಯ್ತು. ಅದು ಪಾಲಿಗ್ಲಾಟ್. ಎಸ್ ಎಸ್ ಸರ್.
ಇಲ್ಲ ತಮ್ಮ ಮುಂದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋಷ್ಟು ಕೆಪಾಸಿಟಿ.
ಎಸ್ ಸರ್.
Lord, having heard my learned friend Mr. Singhvi, my lord, appearing on behalf of the petitioners, I would put his submissions, my lord, in three silos. One on law, second, my lord, on facts, the third, my lord, rhetoric with some sarcasm. Insofar as the third is concerned, my lord, I don't think I need to spend my time.
What is the third?
Rhetoric with sarcasm.
Sarcasm.
Yes.
Right.
And so far the third is concerned, my lord,
All right.
I will not detain your lordships because I do not think it is appropriate for us to do that. Though, my lord, I can
Lot
reply
of
to that.
rhetoric has happened.
My lord,
Lot of rhetoric has
that's what I'm saying, my lord. A lot of rhetoric has happened, though I can reply to it, my lord, in the same manner, but I will not.
No,
Waste it
it's
all
all-
time. Now, my lord, coming to I would first address your lordships on the question of law, my lord, which I want to place before your lordships a slightly different perspective, so that, my lord, your lordships will define the contours of interference in a judicial review proceeding with respect to an action purportedly taken under section 17A. Kindly now see section 17A for a minute, my lord, in the perspective in which I want to place it before your lordship. I know it has been read to your lordships ad nauseum, but let me place it in the manner in which
Yes.
I would like your lordships to kindly read.
Yes.
No police officer shall conduct any inquiry, investigation into any offence alleged to have been committed by a public servant under this act, where the alleged offence is relatable. Your lordships may mark that word, my lord. There is something that turns on this word. Where the alleged offence is relatable to any recommendation made or decision taken by such public servant in the discharge of his official functions or duties without prior approval. So, my lord, this section does not contemplate even an application. Please contrast this with section 19, my lord.
No, sanction operates on a different footing.
No, there, my lord, under 19, it contemplates a request.
Yes.
17A doesn't even contemplate a request.
It's all right. We'll see.
No, my lord, what was told to your lordship was that it is only the police officer who can go and seek
So
for...
that, if you see, that I straight away dispelled.
Yes.
For the reason that no police officer can begin investigation unless there is an approval. That doesn't mean police officer only should seek approval.
Exactly.
That I
And
already
in fact,
said.
my lord, the question of seeking approval itself is not contemplated under 17A. It is permissible that the authority acts on information which is available in public domain or otherwise without even a request being made. This becomes material, my lord, in the context of the serious submission that was made before your lordship, that a copy of the petition that had been submitted by respondent number 4 was not furnished to the petitioner, and that is a grave infringement of the mandatory requirement of 17A.
If the foundation itself does not require,
Exactly.
why would a superstructure require?
Exactly, my lord. That's what I wanted to point out, your lord.
All right, next.
Therefore, that's first subject. Then, my lord, the second question would arise in the context of 17A. Should the recommendation be made or a decision to be taken by a public servant? It is to be relatable to.
No, in this case, relatable,
Yes,
quite debatable. We'll see.
exactly,
Yes.
my lord. Relatable is debatable, my lord. I bow down. That is why an inquiry.
Yes.
My lord, if it was...
That is why an inquiry will see.
that's my submission, my lord.
Relatable is debatable.
Relatable is debate. That's right, my lord. I mean, at the stage of 17A application of mind, there is no material which is available which can point in one or the other direction. It is a matter where suspicion, needle of suspicion.
No. Needle of suspicion pointing at a particular act of a particular person.
Quite right.
See, needle of suspicion also cannot be in thin air. So there should be something. And he has threadbare told what is there. We'll see whether it is relatable or not.
Quite right. Now, my lord, another important aspect that I want to bring to your lordship notice is relatable. No police officer shall conduct any inquiry or investigation into an offence alleged to have been committed by a public servant under this act. Now, what are the offences under the provisions of the PCA Act? My lord, kindly see section 7. My lord, there's something that turns on section 7, my lord, which I want
Criminal
to point.
misconduct by a public servant.
No, my lord, there's
So this
something
is,
more. There's something more. I want your lordship to be kind enough to see section 7.
Yes.
Any public servant who,
The offense relating to public servant.
yes, quite, no, my lord,
No, see, 7 is offense relating to public servant being bribed.
no, my lord, kindly see C.
The 7C is, 7C,
7C,
7C is the only thing that is something there.
exactly, my lord. 7C, your lordship will kindly see, performs and, no, my lord, more importantly is explanation 1 and explanation 2 to section 7. Performs or induces another public servant to perform improperly or dishonestly a public duty or to forbear performance of such duty in anticipation of, in consequence of accepting an undue advantage from any person. Now, my lord, this is explained by explanation number 1. For the purpose of this section, the obtaining, accepting, or the attempting to obtain an undue advantage shall itself constitute an offence, even if the performance of a public duty by a public servant is not or has not been improper. So, my lord, I ask myself the question, suppose, my lord, in a given case, what has been done is legal. But that legal act has been induced by a public servant.
No, then it does not become an offense.
But then, my lord, I ask myself, what was explanation 1?
legal
Then
act-
kindly see explanation 1.
No, don't, not the self-golagman.
No, my lord, kindly, no, not in this case. Kindly see explanation 1. Otherwise, explanation 1 will have no meaning. Because for the purpose of this section, obtaining, accepting, or attempting to obtain an undue advantage shall itself constitute an offence, even if the performance of a public duty by a public servant is not, or has not been improper. So let us assume, my lord, in a given case that it is not improper. I am not in this case, my lord. I am saying, look at the width of the inquiry that is required to be made under section 17A. It is for that purpose, my lord, that I am pointing out this. In this case, my lord, I am going to show to your lordships a few more facts.
2 more facts are there.
Yes, my lord. Yes. I am going to show to your lordships a few.
More than what he has told.
Yes, my lord. Yes, my lord. There is something more. And on the same facts that my learned friend has placed before your lordships, my lord, I want your lordships to look at it in a manner in which I would like to place it for your lordships.
Different angle.
Different angle, my lord. Therefore, my lord, that would throw some light, would move assistance to your lordships
All right.
to see as to whether in this case there is something that requires to be investigated or the investigation to be scuttled without anything more. Because if the investigation is scuttled and the governor's order is set aside, there will be nothing more to be done in this case. Unless, my lord, it's a question of re-examination, rewriting that's a different matter. But
the submissions are otherwise. If you leave that also, everything subsists,
that's it.
is what he has.
I will, your lordships may look at that also. I'm not saying no. I'm not saying no, my lord. But there are different ways of looking at the same
That's
issue.
why yours is a different angle.
Exactly, my lord. That's why, my lord, when a lawyer, my lord, wanted an adjournment in court on the ground, my lord, that he had forgotten his spectacles. That said, not necessary. Take my spectacles. I'm not going to grant you an adjournment. And the lawyer, my lord, used the judge's spectacles and still said, I want your on an adjournment. He said, why? I'm looking at a case from your point of view. I want to look at it from my point of view. So, my lord, the way, my lord, one learned counsel looks at it, the way your lordship looks at it, the way I look at it are all different. Therefore, my lord, I want to place it from the point of view of how I would look at it. Now, my lord, I have to give a meaning to explanation 1. What is the purpose of saying even if the performance of a public duty by a public servant is not or has not been improper? Now, my lord, suppose, my lord, a legal thing is done in a given case, but it has been induced to be done by a public servant for the purpose of gaining an unfair advantage. Would that amount to an offense under the Act? My lord, explanation 1 seems to suggest that. Otherwise, my lord, these words, shall itself constitute offense even if the performance of a public duty is not or has not been improper. Therefore, my lord, it appears as if the philosophy of the Prevention of Corruption Act is do not use your public office to obtain an advantage.
Legal or illegal?
Exactly. All right. That seems to be the high pedestal of public morality, which, my lord, the Prevention of Corruption Act seeks to protect, my lord. Then, my lord, please look at explanation 2 in the same section, section 7. For the purposes of this section, the expressions obtains or accepts or attempts to obtain shall cover cases where a person being a public servant obtains or accepts or attempts to obtain any undue advantage for himself or for any other person by abusing his position as a public servant or by using his personal influence over another public servant or by any other corrupt or illegal means. So therefore, my lord, even if you have used your personal influence, not necessarily as the boss, even if you have used your personal influence, it comes within the mischief of section 7. My lord, in a given case, my lord, let's assume a public servant, a minister, my lord, is not in charge of the department. He has no role to play, but uses his personal influence. My lord, would it constitute a offense under section 7? Explanation 3, explanation 2 seems to suggest yes, it is. The moment you hold a public office, it carries with it certain obligations and certain do's and don'ts which are not attached to a non-public office. Therefore, my lord, even if you are not directly connected, but if you have used your personal influence over a particular matter in respect of which a decision has been taken and you are the beneficiary, that itself constitutes an offense under explanation 2 to section 7. Therefore, my lord, the contours of a offense in respect of which an inquiry is required to be held under section 17A are very wide. That's the point I'm trying to make for your lordship's consideration. Lord, it is not like a complaint which requires ingredients of the offense to be mentioned in the complaint, without which your lordships day in and day out interfere under 482 and quash it.
That's after registration of the crime.
My lord, it is after registration of the crime at the stage of investigation. Yes. But it could be, my lord, it never reached the court, excepting on FIR. Now, in a situation of that kind, even if there is, in the instant case, there are no allegations in the complaint. There is nothing. Still, if the sanctioning authority in the instant case being the Honorable Governor says, well, there is something that requires to be inquired into, not necessarily, my lord, as a list between A versus B, because the philosophy of 17A is different. The whole philosophy of the PCA Act is different. The philosophy, my lord, is to have a purity in public administration. That, my lord, is the paramount object of the Prevention of Corruption Act. If from that point of view, the sanctioning authority says, well, it is as important to be clean as it is to for the people to have confidence in a clean administration. Now, please look at it from that point of view, my lord. It's really not in the nature of a list between the petitioner and anybody else. It is in the interest of purity of public administration. If in that anxiety, if the sanctioning authority says, having regard to the high position that a person is holding, it is necessary that it should be inquired into, I ask myself, what is the scope of interference in a 226 judicial review proceedings? That, my lord, would be the approach I would suggest to your lordships to adopt in this case. It is really not a list between A versus B. There is an element of public interest, and if in that anxiety, the high functionary like the governor, and I will point out to your lordship the judgment, my lord, which of course your lordships will be aware of it, that where a discretion is vested with a high functionary, the courts would be very reluctant to interfere with that order. My lord, your lordships are not going to look at, I would respectfully submit, with the order passed by the governor in under 17A, in the same manner in which your lordship will look at an order passed by the Tahsildar.
It was submitted.
My lord?
That was argued. I think.
Yes. So therefore, my lord, if it is so, and I'm going to show you some authorities on that. If that is the position, what is the extent to which this court can go into while examining the action of the governor acting under 17A being a constitutional functionary? So therefore, my lord, what I would submit to your lordship is, please look at it from the point of view, not as an adversarial litigation. When your lordships are looking at the sanction under 17A, do not look at it as an adversarial litigation. Please look at it from the point of view of ensuring not only there is purity in public administration, but that public confidence in administration is not sullied. If it is damaged, it is restored. What is the best way of restoring, my lord, an eroded public confidence in administration?
Where is it eroded?
Well, let me develop it, but I will show to your lordships that. What is the best? Because it is the very fact that a commission of inquiry has been constituted under the Commissions of Inquiry Act itself indicates that there is an anxiety to get this matter inquired into because it is a matter of public importance. And that has been referred to by the Honorable Governor in the order. If it was a matter in respect of which no inquiry was required to be done, I ask myself, why was a commission of inquiry required? Whole object of the Commission of Inquiry Act is that you will have this inquired into in accordance with a special statute. In order, my lord, your lordship knows, my lord, that the report of the
So
Commission
you are
of
satisfied with the Commission of Inquiry?
No. I
What is your
tell you,
suggestion?
lordships why. I tell you, lordships why. Commission of Inquiry Act, unfortunately, my lord, a report of a Commission of Inquiry has no teeth.
We'll give it.
My lord, but the statute doesn't, my lord. The statute doesn't, my lord. In fact, there's a recommendation made by the Supreme Court saying that something must be done, nothing has been done. And the Supreme Court, my lord, has recognized that all these commissions of inquiry report are put in cold storage.
We will not permit.
My lord, but that is an independent and a parallel remedy. That is not necessarily a bar to a sanction under 17A. Therefore, my lord, this submission I made is in answer to the aspect, my lord, of eroding public confidence in public administration. How is it eroded? The very fact that you constitute a commission of inquiry indicates that there is something to be inquired into. Is it something that does not require a matter of public importance is what the Commission of Inquiry Act
Then there is
says?
something being inquired into.
Yes. Yes.
Why all this exercise?
My lord.
Why all this exercise?
Of course, my lord, there are two parallel remedies. Of course, there are two parallel remedies.
Don't emphasize on what is being inquired into.
No, that is only to answer the question, my lord, as to where is the erosion of public confidence. If there was no fear of erosion of public confidence in public administration, then the question of constituting a commission of inquiry would not arise. It is from that point of view I am making the submission that the very fact that the government itself considers that there should be an inquiry into this matter and a matter of public importance itself indicates there is something that required to be inquired into, and all that is required under section 17A is that there is something to be inquired into, and the entire allegations, my lord, are with respect to persons holding public office. Maybe, my lord, ultimately after inquiry there will be a clean sheet. Maybe not be, I don't know. But why scuttle it at this stage? I mean, why not? Whatever is the truth, maybe, my lord, there is truth in what is being alleged. Maybe there is truth in what is being said for the other side. We don't know at this point of time. Therefore, at this point of time, would your lordships want the cloud on the purity of public administration to remain? Is a question, my lord, I ask myself and pose it for your lordship's kind consideration. And I would say, my lord, that in matters of this kind, the courts must lean in favor of getting matters inquired. Not,
ನೀವು ಅಷ್ಟೊಂದು ಪಾಸ್ ಕೊಟ್ಬಿಟ್ರೆ ಮಧ್ಯದಲ್ಲಿ ಕಷ್ಟ ಆಗುತ್ತೆ.
ಅದು
Courts. Which side? Lighter way, yes.
ಅದೇನಾಗುತ್ತೆ ಅಂದ್ರೆ,
In the lighter ways.
I know,
Mind,
I,
yes.
no, I fully
Yes,
understand.
yes.
I fully understand, my lord. We have seen your lordships for quite, and we have gauged, my lord, to the best of our ability
Yes.
as to what the court means when the court is asking a question. We know that. The one thing that we are never able to gauge, my lord, and rightly so, is what is the final decision.
Oh, if you gauge that, then what is?
Exactly, we can't do that. ಅದು ಸ್ವಲ್ಪ ಕಷ್ಟ.
Yes.
ಅದು best is not to do it, my lord.
Yeah.
So now, my lord, coming back to the point, my respectful submission to your lordship is please lean in favor of getting matters inquired into. That consideration when your lordships are looking at 19 would be different, and we are not concerned with that
Operates on a
today,
different
in a different. Now, my lord, having told your lordship that, my lord, I prepared a list of dates and factual aspects, and I want to take your lordship through a few factual aspects which is relevant.
ರಂಗನಾಥ್ ರೆಡ್ಡಿ ನಿಮ್ದು ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ. ಪೂರ್ತಿ ಇಲ್ಲ. ಎಸ್.
Please note, my lord, just a few things that between 1996 and 1999, I mean, this is not there in this. I would trouble your lordship to kindly just note these periods.
1990?
6 to 1999, the petitioner was the deputy chief minister.
ಇದ್ರಲ್ಲಿ ಇದೆಯಾ ಅದು? ಇಲ್ಲ.
ಅದೊಂದು ಮಿಟ್ಟೋಗಿದೆ.
ಮೋಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್ ಬಿಟ್ಟು.
ಅದಕ್ಕೋಸ್ಕರ ಅಧ್ಯಕ್ಷರು ಯು ನಾಟ್ ರಿಟನ್ ದಟ್ ನೋ. ಐ ಆಮ್ ಸಾರಿ ಮೈ ಲಾರ್ಡ್, ಐ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್.
Right.
ಅದಕ್ಕೋಸ್ಕರ ಶುರು ಮಾಡಿದೆ, ಅದನ್ನ ಬಿಟ್ಟೋಗಿತ್ತು, ಅದಕ್ಕೋಸ್ಕರ ಶುರು ಮಾಡಿದೆ. 1996 to 1999,
ಹಾ.
my lord, the petitioner was deputy chief minister.
ಡೆಪ್ಟಿ ಚೀಫ್ ಮಿನಿಸ್ಟರ್. ಹಾ.
2004 to 2000, I'm giving the dates which are relevant. 2004 to 2005, he was again a deputy chief minister.
1 year.
Yes.
ಆಮೇಲೆ
The first stint as chief minister was, my lord, between 2013 to 2018.
18.
And thereafter, my lord, the second stint is from May 2023.
One moment.
We are concerned with the property, my lord, bearing number survey number 464,
ಕೆಸರೆ
measuring
ಗ್ರಾಮ.
3 acres and 16 gundas.
ಕೆಸರೆ ಗ್ರಾಮ ಕಸ್ಬಾ.
Exactly, my lord, exactly.
Yes.
My lord, this property was originally owned by one Ninga.
Granted.
Yes, my lord, it was granted and he was the owner. And he, my lord, had 3 sons, Mallaya, Mailaraya and Devaraju. My lord, Mallaya and Devaraj relinquished their right in favor of Mailaraya. That your lordship gets it, my lord, at serial number 2 in the list of dates. Relinquishment deed by Mallaya and Devaraju over survey number 464 in favor of Mailaraya. Therefore, my lord, Devaraju had no right. It was property was owned by Mailaraya. It is noted that Devaraju name is shown in the revenue entries after Ninga and the name of Mailaraya is not depicted in the revenue entries. Then, my lord, I am going to skip to a few things. Then your lordship may come to serial number 4. In 1991, Karnataka Urban Development Authority's incentive scheme for voluntary surrender of land rules 1991 came into force, while GO dated 29th of January 1994, retrospectively from the year 1991. According to the rules, a person is entitled to 4,800 square feet when the land is acquired between 3 acres to 4 acres. That is, my lord, they were entitled to, my lord, 2 sites. If the
Between
land
3
is in excess of 3 acres.
3 acres.
My lordship may look at the rules, my lord. Your lordship may look at the statement.
All
of
right.
this.
ನೀವು Yes.
Then, my lord, please look at serial number 6. No, I'm going to skip a few dates, my lord. May not be.
No
It is given only for the
No,
purpose
you
of
can-
convenience. I'm
Narrate all the dates, no problem. But rules will go later.
very well, very well.
Yes.
Now, my lord, please look at serial number 6. Government of Karnataka acquisition of land for development of Devanuru third phase by Muda 3 acres 16 guntas of survey number 464 was mentioned in notification. Notification reflected late Sri Ninga's name. My lord, the notification is available for your lordship's consideration. Now, my lord, kindly see interestingly what happens is serial number 8. Devaraju sought for denotification of land.
Devaraja was not the owner.
No,
Mailaraya was the owner.
exactly.
Hmm.
Mailaraya was the owner because of the 1968 relinquishment
All
deed.
right, yes.
Devaraju sought for denotification of the land. Endorsement of Muda recommending denotification of land, that is on 30th of August 1997. And now, my lord, final notification issued on 20th of August 1997 where this property is acquired. It is at serial number 40.
It was not yet denotified.
No, it was, in fact, this is the final notification.
No. But what is this denotification?
The recommendation. He made an application, there is a recommendation.
Recommendation on 38/1997.
Yes, correct.
All right. But just before that, a final notification is issued.
Yes,
All right.
exactly. And the notification and that relevant property, my lord, is at serial number 40 of the notification, the number of properties. Then, my lord, 30th of March 1998, an award is passed. And the amount, my lord, has already been deposited in the revenue treasury. It has been deposited. So with that, my lord, acquisition is over now. There is nothing more to be done. Then comes the notification, my lord, at serial number 11. 18/5/1998, where there is a denotification of the survey number 464. This is where, my lord, the problem starts.
This was the only land denotified or anything else?
My lord, I'll check, my lord. I'll check until I answer your lordship's question. My lord, kindly, I tell you, lordship, my lord.
No problem. Later you can tell.
My lord, answer to your lordship question is only this land.
Only this land?
Yes. It is at page 109.
Nobody had applied for denotification?
No, my lord, I don't know whether anybody had applied, but the fact of the matter is that the denotification of 18/5/1998 is pertaining only to this land.
All right.
And we are given the reference number, my lord, as a statement of objections.
Huh.
Then, my lord, interestingly, on 25/8/2004, Devaraj, my lord, sold this property to B.M. Mallikarjun, my lord, who is the brother-in-law of the petitioner. And thereafter, there is a site inspection report. My lord, your lordship gets a site inspection report. Is it in your new list of dates, 5/3/25?
Is there?
My lord, there is
Yes.
one site inspection report
He has
of
taken this
5th of March 2005. Your lordships have seen that, my lord.
2 inspections are done. DC says he himself has inspected
Yes,
it and
correct.
conversion is granted.
Correct. In that, I'm going to point out some very telling facts,
Huh.
which I'll come to. Shall I do it right now, my lord?
Yes, sir.
Please be kind enough to turn to page 125.
Of the objections,
Yes, my lord. My lord, page 125 is a communication from the Tahsildar to the Deputy Commissioner dated 5/3/2005. Please be kind enough to turn to page 126. And he says, my lord, he has done an inspection on 4/3 and the last paragraph at page 126. ಸ್ಥಳ ತನಿಖೆಯಂತೆ ಕಂಡಂತೆ ಹಾಗೂ ಅರ್ಜಿದಾರರ ಕೋರಿಕೆಯಂತೆ ಕಸಬಾ ಹೋಬಳಿ ಕೆಸರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 466ರಲ್ಲಿ ಒಟ್ಟು 3 ಎಕರೆ 32 ಎಕರೆ ಜಮೀನಿದ್ದು ಈ ಪೈಕಿ 16 ಗುಂಟೆ ಜಮೀನಿದ್ದು ಈ ಖರಾಬಿನಲ್ಲಿ 5 ಗುಂಟೆ ಆ ಖರಾಬಿದ್ದಕ್ಕೆ ನಿಯಮಾನುಸಾರ ಪರಿವರ್ತನಾ ಶುಲ್ಕ ವಿಧಿಸಿ ಉಳಿಕೆ 3 ಎಕರೆ 16 ಗುಂಟೆ ಜಮೀನನ್ನು ವಸತಿ ಉದ್ದೇಶಕ್ಕಾಗಿ ಭೂ ಪರಿವರ್ತನೆ ಮಂಜೂರು ಮಾಡಲು ವಿಶಿಷ್ಟ ಕಡತವನ್ನು ತಮ್ಮ ಅವಗಾಹನೆಗೆ ಸಲ್ಲಿಸಿದೆ. ನೌ ಪ್ಲೀಸ್ ಲುಕ್ ಎಟ್ ದ ನೆಕ್ಸ್ಟ್ ಒನ್ at page 127. This, my lord, is spot inspection. Mysuru Taluku Kasama Hobli Grama survey number so and so ಕೋರಿ ಶ್ರೀ B.M. ಮಲ್ಲಿಕಾರ್ಜುನ ಸ್ವಾಮಿ ಬಿನ್ ಮರಿಲಿಂಗಯ್ಯ ಮೈಸೂರು ಇವರು ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿಯ ಬಗ್ಗೆ ತಾರೀಕು 17/6/2005 ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಿರುತ್ತೇನೆ. ತಾಲೂಕು ತಹಸೀಲ್ದಾರ್ ಹಾಗೂ ಇತರೆ ಸಿಬ್ಬಂದಿ ಹಾಜರಿದ್ದರು. ಮೈಸೂರು ತಾಲೂಕು ತಹಸೀಲ್ದಾರ್ ರವರ ಪತ್ರದ ಸೋ ಅಂಡ್ ಸೋ ಪ್ರಕಾರ ಪ್ರಸ್ತಾವಿತ ಜಮೀನು ಅರ್ಜಿದಾರರಿಗೆ ಕ್ರಯದ ಮೂಲಕ ಬಂದಿದ್ದು ಖಾತೆಯಾಗಿ ಸ್ವಾಧೀನಾನುಭವದಲ್ಲಿರುತ್ತಾರೆ. This is when acquisition is complete. The question of their being in possession would never arise. This is such a blatant.
No, but it was denotified.
Subsequently.
Oh.
Subsequently. The denotification was in 2008.
1998.
1998.
This
Yes.
spot inspection is 2005.
Correct. But it's already acquired. Where is the question of their putting in possession?
No, that is why I asked. Recommendation was made for denotification.
Correct.
Where is the order of denotification?
Nothing, excepting, my lord, what happened on 20th, when, my lord, there was on 18/5/1998.
No, that is an order.
Notification, yeah, that's a notification.
Then it was denotified.
Yes, it was only on 18/5/1998.
It's all right.
Yes. Yes, my lord.
We don't have auto payment.
Huh?
We don't have the auto payment.
Yeah, if your lordship says, is there a order of no denotification, we don't have it. But
Notification.
notification is 18/5/1998. It is at page 109, which
All
when your lordship asked me, is this the only property which has been denotified? My answer to your lordship's question was, yes, that's the only property which has been denotified. Now, the first question that arises, my lord, is where is the question of this denotification? How can this denotification at all be done? Is it not glaring act of doing something which is not provided by the statute? When the property is vested, where is the question of a denotification? Now, in that context, my lord, if possession has been, if they say possession is with the Devaraju, I ask myself, how did possession go to him? Nothing that is available on record for your lordships to come to a conclusion this way or that. That is the reason why, my lord, it is only in areas where it is a gray area that inquiry is required. My lord, in fact, my lord, the very fact that so much of submissions had to be made to your lordships in order to point out whether the needle of suspicion is to be pointed this way, that way, or none at all, itself indicate that something has required to be looked into. It is only that much that is required to be done today. If it was open, black or white, no inquiry is required. It is only in gray areas that inquiry is required. This is a case falling within gray area. Therefore, my lord, all that is required to be done is just inquire into it. I fail to understand, with due respects, why this case has been elevated to the level of taking your lordship's time over and over again for the simple purpose of simply an inquiry. In a situation of this kind, my lord, let us assume, my lord, the PCA Act was not there and simple complaint had been filed, where there was no this filtration process, my lord. Let us assume it was not there. And I ask myself, if a complaint had been filed with the police authorities.
ಅದಕ್ಕೆ ಫಿಲ್ಟರ್ ಬಂದಿರೋದು.
ಇಲ್ಲ ಬಂದೆ. And it had come to your lordships under 482. I ask myself the question, would your lordship interfere? I would say no. Your lordship would say, look, in the complaint there are some allegations. Let it be inquired into. I ask myself, why is it that same test should not be done for the purpose of 17 years? 19 is a totally different kettle of fish. It's totally different. 17, is this a case where your lordships will interfere? I ask myself under 482 if a private complaint had been filed in the absence of PCA. Obviously, you will say, look, allegations are there. There are gray areas which requires to be examined. Let it be examined. What's going to happen to you? Nothing. I think, my lord, that is the way. I'm not oversimplifying it.
Just simplifying.
I'm not even simplifying it. I'm only saying, my lord, that's a legal position. And I think, my lord, we have complicated the issue more than what the issue warrants. It requires to be seen in this way. And if that is done, several objectives would be satisfied. One of them is this a complaint which does not warrant any investigation? If it is in the white area, your lordship will say yes. It doesn't warrant any investigation. That's the object of a filtration process. But this case, my lord, is in the gray. I mean, it's all right to say one way or the other, but we are at the stage of inquiry. Now, my lord, please look at the other dates that your lordship will kindly look at.
No, you said there is a needle of suspicion.
Yes.
Is it a needle in a haystack or what?
I would not say it's in a haystack because, my lord, needle in a haystack is possibly something so trivial. We use that expression, my lord, normally to convey a very trivial, a very small thing, a very something so insignificant.
It's not that.
This is not that. Because it concerns purity of public administration. I can understand, my lord, normally this expression pin in a haystack is only to convey something very trivial.
That's why I said, what kind of needle?
But we don't know. It requires to be examined. The very fact that there is an allegation that has been made of this magnitude, and prima facie here is Devraj, who was not the owner of the property. He makes the application. At his instance, all this is being done. And he conveys the property in favor of the petitioner's brother-in-law, who gives it to his sister. And in a situation where sites have already been formed, now please look at that, my lord. Please look at now that issue. Your lordship may kindly now go to seal number 15. 13, no?
12.
Serial number?
My lord, kindly see, my lord, seal number 12. My lord, in 2003, despite survey number 464 is denotified, MUDA forms layout, parks and roads. Sites are allotted by MUDA to various persons. Now, my lord, then comes Devraju, who says, I am the owner of the property. You have sold my land. He sells the property in favor of the petitioner's brother-in-law. And then, my lord, there is an order of conversion, and then, my lord, there is a gift in favor of his sister. It is on the basis of these documents that the sister now says, please give me compensation / alternate sites. Now, please look at that. Please look at the item number 16. 23/6/2014. Representations made by Parvati for compensatory sites. This is the representation she gives. Now, if an ordinary citizen had made an application like this, I ask myself,
No ordinary person made? No, along with this, there are other applications.
we have
No
nothing
other
on record.
application.
Nothing on record. Nothing on record. We don't have anything on record. Nothing on record.
Then
Nothing on record.
why sites are distributed to everybody?
No. That is the sites which were distributed on somebody else's property to various persons. I'm talking about whether the real owner of a property which had been used by a public authority without going through the process of acquisition. No such instance. This is the only instance.
All right.
Now, my lord, please look at if an ordinary person had made an application like this, what would have been the attitude or the approach of the authority? Look, tell me who you are. What is your source of title? Please prove your title before I can even look at your representation.
And a mandamus before this court.
If that's not done, a mandamus by your lordships.
Direction to consider.
Exactly, my lord. Your lordships are right. Consider we have hundreds and thousands of cases where representations are made, not considered. Your lordships issues mandamus saying do it within 3 months, 4 months. Now, all this is not necessary in this case, my lord. It's not necessary for obvious reasons. The reasons are not far to see. That is what is required to be examined. What would the authority do if there was a representation by an ordinary citizen with respect to this, assuming that they are taking action, not sitting over it? They would say, look, there is a communication sent by one Parvati. Now, who are you? We don't have your name at all on record. We don't know who you are. Please prove your title. No such exercise. Nothing done. Straight away, now please look at, then the rules are amended, make it 50-50. As of 11/2/2015, it is on the basis of this rule of 2015 that 50-50 compensation is given. My lord, I have two as
50-50 compensation.
50% of the extent of land which has been unlawfully
So
occupied.
3.16 acres ಅಂದ್ರೆ about
Yes, 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 about
half of that.
half of that. That's the formula. That's the formula in this new amended rule. Now, my lord, if a property has been acquired and the compensation has all been deposited, the question of even granting one side does not arise. Property has become the property vested in the government. Where is the question of denotification? Now let us keep that aside for a moment. With respect to which rule will you take a decision on the representation that has been made, my lord, on 23/6/2014? It obviously must be with respect to the rule that existed at the time when the allotments were made.
60-40.
Exactly. My lord, your lordship may kindly see when the allotments were made to various persons, my lord.
2004.
2004. I asked myself, how do you apply 2015 and give 50-50? If the encroachment or the illegal occupation was at that point of time, which is the rule which you will apply for the purpose of determining whether a person is entitled to, and if so, how much? By way of a
You accepting 60-40 entitlement?
assuming, without considering, first submission is that not entitled to anything. No, of course not, my lord. Even 60-40, even two sides is not there. The question of my accepting, my lord, not accepting is not the real issue.
No. By submissions, I'm asking.
No, my lord, I don't. Of course not. I am saying that nothing was to be done. But in this case, look at this way in which it has been done. How do you give this 50-50 on the basis of 50-50, which was a 2015 rule, in respect of what is a wrong utilization of the property in 1998? I ask myself, how can it be done that way, my lord? Which is the provision under which they can give this 50-50 rule and give these 14 sites? There is none. It's a submission I would make for your lordship consideration. Because your lordship will kindly see, my lord, that all these sites were allotted. When?
19 allottees in the year 2004.
19 allottees in the year 1900?
2004.
2004, my lord. Yes, your lordship gets it.
2004 ಅಲ್ಲ?
2004. 2003, my lord. 2003.
3 or 4 are.
3 na 4? Oh.
That's why I said he has threadbare covered everything.
Ila, now we have produced one document. Give me page 111.
2009, my lord.
Give me 111.
On continuous process.
My lord, we have produced.
No,
a
it started at 3, sir, then ended at 9.
Continuous process. Continuous.
Available. In a, all, I can. All right. Now, how does 2015 amendment apply? How did you apply this 50-50 rule? Well, everything can be overlooked for obvious reasons. You did not find out as to what is the title of Parvati. You did not go into the question as to whether there can be a denotification when the property is already vested. You did not go into the question of how many sites to be given, whether you will apply the 50-50 rule, 60-40 rule, 2 sites, nothing. How many times do you overlook? And my lord, your lordships have said it a number of times that where repeated mistakes are made, it leads to a conclusion of malafides. My lord, one order which is wrong, my lord, we don't allege malafides, and even if you allege, your lordships will not accept. But even with respect to a court, your lordships have taken the view that if repeated orders are made in the same case which is wrong, then there is a ground for malafides. Now, how many times are the mistakes being made? Now, your lordship may kindly look at the next aspect as to what happens, my lord. Please look at serial number 19.
No, serial number 18, sir.
My lord, kindly see, now serial number 18 is very important. My lord, in December of 2017, resolutions are passed when the petitioner was the chief minister. What was told to your lordship was, well, it was in 2023. Where is the question? I was not there. That's not the date with reference to which your lordships will reckon this case. The date relevant for the purpose of the present submission would be December of 2017. Your Lordship may let's look at that resolution for a minute at page 151 of the writ petition.
Of the writ petition?
Yes, yes.
ವಿಶ್ವ ಪ್ಲಸ್ ಜನಹಿತಕ್ಕೆ